Welcome, or hopefully welcome back to the Reluctant Entrepreneur Podcast, where I talk with founders, innovators, and business owners about their journeys, the highs, the lows, the surprises, and most importantly, the lessons learned along the way. Today, I'm joined by Austin Bonderer, a seasoned patent attorney whose career has spanned both sides of the patent world, from serving as a U.S. patent examiner to founding his own law practice. With more than 690 issued U.S. patents to his name, Austin has helped inventors and companies protect their ideas across industries, including leading nanotechnology patent prosecution for a Fortune Global 100 company. We'll start by exploring Austin's entrepreneurial journey, what motivated him to leave government service, and how he built his own firm from the ground up, and what lessons he's learned about running a specialized practice in the complex world of intellectual property. Then we'll dive into the patent process itself. I'll be asking Austin the questions we all want answered about obtaining patents, how the process really works, how to know if your idea is even patent worthy, and the biggest mistakes people make when trying to protect their innovations. If you've ever dreamed of building something on your own, or if you've ever wondered how to protect the ideas that fuel innovation, this episode is packed with insights you won't want to miss. My conversation with Austin Bonderer begins right now. Stick around. Hey, Austin. Thanks for being here. I'm so glad you're on the show.
Thanks for having me, Mike.
And just to be clear, no billable hours, Austin. No billable hours. This is pro bono, right? Right. You heard it here. So tell me about your early years. What led you toward engineering and then eventually into the world of patents? That's an interesting pivot to have an engineering degree and then get into law.
Yeah, it kind of is. So basically, I was always kind of, really bad at English and, this kind of stuff. And math and science was where I was always drawn to. So I was just kind of that engineering kid. And so that's where I went to school for. There was a point in time where I was thinking maybe I should try something else and move, out of the School of Engineering and into what we call the School of Arts and Crafts. And they told me I would have to take 2 years of foreign language, and that put a kibosh on that right away because I have a hard enough time with English. There's no way I could do 2 years of college foreign language. So basically what it was is, so I was in the engineering program. In my capstone project, our senior thesis, we had to come up with something. And I decided to have on this invention I always had in the back of my head. And it was a wireless smoke detection system. So basically it was, I put, back when those wireless doorbells came out, I put 2 of those on 2 different smoke detectors. And the idea was that you could put them up in your house. And when one went off, wirelessly, it would make the other one go off, which would make the other one go off. And that way, you could easily have a smoke detection system installed in your home without crawling through the attic. And the backstory on that is that my dad's house almost burnt down one summer. So I was the one in the attic climbing through, putting these wires in the heat of the summer in southern Mississippi. And I was like, there's got to be a better way. And then when the wireless kind of stuff came out, I was like, this is the answer to prevent me from ever having to do that again. So,
Right.
Problems are always the mother of invention.
Yeah, I'll tell you, I'll give you another thing that you should patent. We have a pretty big house, and there's a number of smoke detectors, mandated to be in the house. And they're all wired to AC, but there's a battery, obviously, a little 9-volt battery, and each one of them is a backup battery. And about once a year or so, the battery starts to fail, and it puts out a little chirp. And I think those chirps are intentionally designed by sadistic engineers to be almost non-directional. I can't tell which of my 7 battery smoke detectors are chirping, because when I'm under the one that's chirping, it sounds like it's coming from over there. And then I go over there, and the chirp comes from somewhere else. And they only chirp like every 3 minutes. So it takes me an hour to do it. And then what I eventually do, which is probably a good move anyway, is I just say, okay, Uncle, I'll just take my ladder and go around and change them all. right? So they're all
Right.
fresh. And that actually takes about the same amount of time as locating the one offending smoke detector, right? Or flash a strobe light or LED or something. Make it more obvious that I'm the one wanting attention. If the alarm went off, I could easily detect where it's coming from. But that little chirp is just too hard to find. Food for thought, Austin. If you ever decide to get back into engineering, we need that.
Well, I feel your pain. The problem I always have is for some reason they always start at night when you're sleeping.
I
Like, right?
It's that sadistic engineer. Probably put a little
Yes,
photocell in it, and if it's super dark, they will start chirping for sure. That's
exactly.
a rite of passage. You worked as a U.S. patent examiner before starting your own firm. What
Yes.
inspired you to leap from government work? I can see maybe today why you'd want to get out of government work because our current government is not friendly to federal workers right now. But
Right.
what inspired you to leap back then from government service, which was always considered to be a pretty stable, safe, consistent type of job, into the very unstable, unguaranteed world of entrepreneurship?
Yes. And trust me, my mother let me have it. She was like, "You left this government job, this wonderful government job." And I was like, "Yes, I did." Basically, one of the biggest drivers for that was I didn't want to have to live in Washington, D.C. my whole life. And at the time, if you were a patent examiner, you had to live there. So I went to law school at night, uh, you know, end up getting my license and that kind of stuff. And I was just like, it's time to go. So I went out, started working, started my own firm, and then eventually got on with uh, Foxconn. And that's who I
Yeah.
ended up working with for a long time. And at a certain point, it was just kind of like we decided we would still work together, but I would become, they basically would hire my law firm. And that's what helped me move into building my business, outside of what used to be my employer.
So it sounds like you were kind of a outside, inside counsel for
Yes.
Foxconn.
Yes. Yeah. Became an independent contractor, but when you work in, it's lawyers are much easier able to do that than a lot of other, specialties and occupations.
And for my audience who may not know who Foxconn is, y'all are aware of them, unassumingly aware of them, because if you have one of these, they built it. I'm
Right.
staring at a MacBook Pro. They built it. Foxconn basically builds pretty much all of Apple products, and
Yes.
they're probably one of the largest contract manufacturers, electronic contract manufacturers in the world, in China and Taiwan and all of that. Was starting your own practice something that you, in the back of your mind, always planned to do, or did it happen kind of more out of necessity or opportunity? I'm hearing a little opportunity from your last answer, but did you always kind of pine for, your own ship to sail?
Yes, 100%. I mean, there are certain people. I think I was a good employee, but I always felt that there were better ways of doing things, and almost to the chagrin of some of my bosses. Hey, we do it this way. There's a reason we decided to do it this way.
Stay in your lane,
Thank you for
Austin, right?
exactly stay in your lane, stay in your lane, and and also culturally with some of the different cultures. That company specifically, if you tried to offer too many advice or improvements, they thought you were trying to take their job.
Yeah,
So, and I don't know if that happens, U.S. employers as well, but it
I
seemed
think
like
it
they were
does.
very sensitive to that. Yes.
Well, what's the rule?
So,
Was it Robert Parkinson's rule of business? I forget who wrote this, but several rules of business. One of them is that if you consider yourself on a scale of aptitude a 10, you will, and then you get into position to hire people, you will always hire nines or lower. And then the nines come in and they start to hire eights. And then the eights come in and you can see the trend there. And it's kind of a de-evolution of capability. And that's kind of human nature. So if you're a 10 and someone is working for you that appears to be, a 12 or 15, human nature is you're instantly suspicious of them. because if they wanted your job, they might be able to take it, right? So, and they may not have any interest. In fact, probably most of the time they don't, but that's certainly human nature.
Yeah.
Whether you're dating someone and your girlfriend's best friend is George Clooney, you're worried about that, right? It's like, I'm not a George Clooney. I can't compete.
Oh.
What were some of the biggest challenges you faced in launching your law practice?
Um, it, I think, and I'm sure most entrepreneurs will say the same thing, is the amount of work that's not billable, that has, you would think, has no real bearing on what you got to do, but it's the regulations, the accounting, the bookkeeping, the banking, all this other stuff. And
Podcast interviews.
podcast. No, this is fun. But and I remember at the time when I started, and you're talking to your accountant, and your accountant's like, you should take things as a shareholder distribution as opposed to income. And I thought that was kind of a odd thing. But after being in it, you fully understand how much of your time and work is actually stuff that you can't make money on. In
Yeah.
fact, cost you money, and you're just spending all your time on that.
Yeah.
So
Yeah. I use the distribution model as well. I'm on payroll, but I also am on distribution, and there's lots of advantages to that, from a tax standpoint and all that. How did your experience as a patent examiner prepare you, or maybe not prepare you, for running your own business?
Oh, it's totally different. I mean, there is something nice about someone making sure that you're productive at work. And when they do that, they make sure you have something to do every day and it's there in front of you. You leave at 5 and there you go. The big issue is, when you start working for yourself, you eat what you kill. And
Yeah.
that's the way it goes. And, if you're not killing something, you're starving. And, doing this when you have a family and, payments and responsibilities, it can get pretty stressful.
And it's, to continue that analogy, you're not just killing something, you're gutting it, you're prepping it, you're storing it, you're cleaning up everything afterwards, you're surveying the next hunting site, you're buying the gear. I mean, I guess when you work for a company for and perform a specific task, you kind of take for granted that someone else is doing payroll, someone else is doing HR, someone else is doing compliance, someone else is training, someone else is shipping. And, we think, my experience is, it's like if I go to a restaurant a lot, which I do because I travel for a living, I might falsely assume I could run a restaurant. I mean, I've got a lot of experience in restaurants, yet I've never been, back at the counter, back of shop, or in the kitchen and do the ordering. I don't have any idea how that works, but because there's a familiarity, we all think, oh, I can do it. Why work for someone? Why not just be that someone? And
Yeah.
it is a little bit of a wake-up call. It's definitely a splash of very cold water in your face when you realize that there's no bell you can ring and summon some help. It's you or nothing. Particularly in the early days.
One of the hardest things was when you start your own firm, I tell people to go to work at a law firm. And mainly that's because just one of the simplest things is all the forms that you use, all the paperwork, these things, someone has already formatted that for you. And if you have it, you have to do it from scratch. And, you spend 2 hours creating a template that you're going to use forever, but still it's just so much time spent on mundane things, especially in a law firm.
Yeah. And even very mundane, like not technical things like ordering stationery and business cards and developing your website and, getting phone service and all of that stuff and checking voicemails and, calendar management and all that stuff, that lands on the same person that's, in court. It's
Right.
all of that. You emphasize that every client works directly with you rather than being passed off to an associate or a paralegal. That's the advantage in working with a solopreneur attorney. What was that? Why was that model important to you?
Well, it's very important to me for several reasons. I mean, one of them was, I used to live in California, and I felt like if you had one employee in California, the headache that you have, you might as well have five or six, or, if you're going up that big. The other part is that I handle I handle my business. And if there's a mistake that's made, it's on myself. Now I understand eventually you may want to, you goal of any business is to make money off of other people's labor, right? That's generally how you multiply your business and this kind of stuff. But honestly, I feel like I've created enough of a market for myself where I've maintained, I've been able to keep myself happy, my family fed, all this other stuff, and able to have the freedom to make sure I made every lacrosse game or this kind of stuff. So I've never been the push of the drive of my business has been to take care of my business. It hasn't been to take over the patent world. So I'm very happy with what I've been able to do with my education and this, and it's put me in a good place. I've been able to basically handle my business and take care of my family and have some fun while doing it.
That's very wise. I used to think that the solution to every problem was to grow. We're having problems at this scale. Let's scale up. And then, the extra revenue and whatever will be greater than the problem. And I was completely wrong on that. When we go from 1 to 2, our problems go from 2 to 10, more than exponential growth in problems. And I learned the hard way that rapid growth, almost uncontrolled rapid growth, while it may seem like a windfall, is actually a death sentence for most small businesses, because I've seen businesses, and mine almost did the same thing, grow to the point where we couldn't manage the business, and then the business crashes. And I've seen a lot of companies do that. We've all seen a lot of companies in the consumer world do that. They just grow. Then all of a sudden their customer service sucks, and their systems crash, and they have to do the public mea culpa and start over again. I think rapid uncontrolled growth is a luxury that most small businesses can't afford. It costs money to grow. Beyond organic, authentic, slow growth, it costs money. And I learned also the hard way, and maybe you too, that when we were a little smaller, we made more money. And it was easier. It was never easy, but it was easier at a slightly smaller scale. And then when we grew, say 50% above that, it was chaotic. We had cash flow crunches. It was tough. And then we'd have to grow another 50% just to get into another sweet spot. And because for us as a manufacturer of equipment, if we want to double our sales in a year, we have to quadruple our expenses, because we have to buy the extra inventory, we have to hire the extra labor, we need more space, we need a larger factory, we have more customers, so now we need more service people and admin people to take care of all that. And you have to grow into it. It's like when I was a kid, my mom would buy me clothes that were intentionally 1 or 2 sizes too big in her mind, so they lasted. I didn't outgrow them too quickly. The problem was they were uncomfortably too big for the first year. They were ridiculous for the first year. Now translate that to a monetary problem, right? You've got to, growing is an investment. And if you don't have the capital, there's no harm in staying small. There's no harm in your goal of take care of the firm, take care of the family, enjoy a work-life balance. To me, that is a great definition of success, not being the biggest, not being, a giant law firm with 1,000 lawyers in 6 states and all of that. God love people who do that. I can't do that. You don't want to do that.
I don't want to do that.
But it's great to know that up front.
Yeah, well, it's kind of akin to what I kind of tell clients is like, you're talking about growing and stuff. Do you really want another baby? Because, it's like when you have 2 children, it's not twice the problems, it's squared the problems.
Yes,
and now
exactly.
Yes. And it's a lot of money and it's a lot of upfront. And you're now, you've quadrupled like you said, your problems and your worries and all the moving parts. And, sometimes you could just grow slow and be happy. And if you're good with that, then yeah.
Yeah, what's really hard for entrepreneurs to do is, put their ego on a shelf. And most of the bad decisions I've made in my 33 years of owning my company were made either through fear or ego, and both are just toxic to the company. And I couldn't see that at the time. Looking back, I can clearly see which were fear-based decisions and which were ego-based decisions. And sometimes they're at odds with each other, but neither of them are the right motivation to make that decision, whatever it was. You've worked internationally and with Fortune 100 companies. How has that shaped your approach to running a small firm?
I've seen a lot of management styles. I guess that's kind of, what works, what doesn't
Probably
work with certain
management in
things.
air quotes, right?
Yeah,
Sometimes.
exactly.
Yeah.
Management. Yeah, something like that. But it kind of gave me the impression that, you know, don't fear the worst. And I don't know how to explain that by seeing all these different companies and things that happen. I've seen projects go belly up and stuff like that. But, I just felt like I've seen the worst and it really wasn't as bad as I thought it would be. So, I think it was Tim Ferriss, one of his things
Mm-hmm.
in books I read. It was like, it's the fear of the worst that tends to paralyze people more than actually if they really contemplate what the worst was and when they're
That's
making these decisions.
that's really great. I agree with that 100%. One of my mentors had an expression which I still use today, and it's similar to that. It's make peace with the worst. What's the worst that can happen? A, will it kill you? Will it physically kill you? Well, no. Will it instantly kill your business? Is it an instant death sentence for your business? Well, no. Okay, what's the worst that can happen? Well, we'll lose money. Okay, okay. Make peace with that. And it's just a mind trick, because once you don't have, you don't want the worst to happen, but if it happens, you recalibrate, you pull back, you pivot, you do whatever it takes, and you don't do it again. And
Right.
but you're right. If you're sitting paralyzed, deer in the headlights, then I mean, deer in the headlights is a real thing. If I've never lived in an area that had wild deer everywhere, but I've seen the remnants of it when I travel. And a deer will cross the street, see the headlights at night, and just freeze. Right now, he's obviously scared, but that moment of paralyzation costs him his life. And I think it can cost us our business life if we're paralyzed. It's better to make a wrong decision than to not make any decision. Now, it depends,
Correct.
that's got a lot of qualifications to it, that statement. But
Right.
overall, in general, I believe that. Looking back, what do you wish you'd known before starting your business that you know now?
Talk to an accountant the first day. Take some kind of, I mean, when I first started, I was like, oh, I'm just going to, and I'm an attorney. I know this stuff. I'm smart. I passed the bar. And of course, I had the worst setup. I just did like solo and didn't set up an LLC and did all this stuff. Now you talk to an accountant. I guess I'm going to spend a couple grand talking to this guy. Best couple grand I've ever spent. It's one of these things. And I remember when I was a member of the Orange County Bar Association, and I told them, I was like, look, all we ever talk about is law stuff. We need to get some accountants in here and business people in here to explain to us, because we're small. It was the small solo, section. We don't know how to run business. They send us to law school. We spend all this time on studying the law. No one tells you how to run a law firm. One, two, it's a business. No one tells you about how to run a business. Yes, you understand tax. You may have taken tax law and all stuff, but there's nothing in there about the nuts and bolts of running a business.
Right.
And I just went into it thinking I was smart enough, good enough, and all stuff. Literally, follow what my dad used to say. He said there are three things you need in life. You need a good doctor, a good lawyer, and a good accountant. Go with that. Make sure you have those people in your life. And if you have a business, make sure you have someone who's good at business.
Yeah, I've said it. You and I have a very similar path, although different specific trajectories, but a very similar experience in that I had a really strong technical acumen. I'm in the electronics industry, and I had a very strong understanding of electronics and mechanical stuff, and I designed the equipment that we sell. But I had absolutely zero clue on how to run a business, absolutely nothing. And I started my business when I was 32, thinking I knew everything because I was smart technically, just like you were smart legally. But I didn't know how to read a cash flow statement. I didn't know the difference between an income statement and a balance sheet. When I discovered the income statement, I just looked at two numbers. I looked at revenue and gross profit, and it turns out there's more to that story. The balance sheet. The initials, the acronym of the initials of a balance sheet are BS, and I used to think, yeah, there's a lot of BS in there because that was my buzzkill. I'd think I'm doing good, and then I'd look at the balance sheet, and I'm like, where did this come from? I don't like the balance sheet. I'm never going to look at it. I don't understand it. And, it's like driving blindfolded. As long as you're going straight and there's no obstacles in front of you, okay. But that's not the way business works. There will be obstacles and windy roads. And driving blind is not a wise idea. And not understanding financials is definitely part of that. I understand it now only through, having to save the company many times because of not understanding it. I just got tired of having to save it, so I figured, okay, I better understand this because all the warnings were there. I just ignored them. So I think that's great advice. Speaking of great advice, let's turn over to the area of law that you practice in, which is patents. I assume that's trademarks too, or is that strictly patents?
I do work in some trademarks, but my forte, my wheelhouse is really just patent prosecution.
Yeah. So is getting a patent attorney to do your trademark a little bit like getting a brain surgeon to, remove a splinter?
Maybe, not really. I mean, yes, any attorney can be a trademark attorney. Only patent attorneys can be patent attorneys. So you have to have a technical background and a law degree, or you can be a patent agent, which is someone who has a technical degree but has passed the patent bar. So those are the only people who can practice before the patent office.
Interesting. Let's start with the basics. What makes something truly patentable?
Well, first, it has to be useful. So you can't have just something that just doesn't do anything, but that's very easy. The next thing is that it has to be novel, which means new. Mm-hmm. Something out there can't be just like it. But the hardest part, and it's the most subjective one, it's where I spend most of my time arguing with the patent office, is what is considered obvious. So, say your invention is A, B plus C, and the patent office has found a reference that has A plus B, and then they found a reference that teaches C somewhere else. And so they'll say it would have been obvious for one of skill in the art to add C to the previous A and B to arrive at your invention. And then we have to argue back and forth. One, it's either technically doesn't match, or technically you can't combine them because of the way the references are, or three, he's got you dead to rights, and that's where you're at. So, this is that's the subjective one. And it's kind of interesting because, while there's one patent office, there really is like 8,500 patent offices because every patent examiner is their own little patent office. Yeah. That's the person you're dealing with. And yes, you can go to an appeal and do this stuff, but generally you're not doing that. So you're dealing with that person for the entire project, and you have to work with them personally. My belief is, since working there, the one thing I've realized is that they're people. Talk to them, call them, have conversations, because then you can truly figure out where they're coming from. Because most of this is done over writing, and I'm sure you've done it before, where you're doing emails back and forth, and where a 5-second phone call would clear the whole thing up.
Yeah.
But the emails were just crossing over each other.
Right.
And, that's what we deal with sometimes.
In the world of patent examiners, I mean, there's so many of them, but is there so many that you never get the same patent examiner twice, or do you sometimes get repeat experiences with the same examiner?
Generally, no. I mean, you're right. There's just so many, and depending on what you do. So there are some patent attorneys who focus on very specific fields, just like the patent examiners. They're focused in a very specific field. So sometimes you'll get the same one over and over again if you're doing that. Other times it's a continuation practice. So we file one patent application for a client, it gets allowed. Then we file what's called a continuation or a divisional. It keeps the patent family alive, but it's automatically assigned to the same examiner because they did the previous work.
Yeah.
They're the most familiar with it. So yes, there are times that I've dealt with patent examiners for years.
Yeah, it sounds like a more expeditious approach than getting someone new and maybe someone that, pees on their own territory and wants to claw back something that maybe another examiner approved. You said that whatever is going to be patented needs to be unique. If I design a widget and there are other widgets exactly like that, none of them patented, just almost like common, common license, whatever. Does that in itself make it not patentable, or can I take something that already exists that has not been patented after the fact and say, okay, I'm going to copy this thing and race you to the patent office?
Well, that's called derivation. So there's something you have to sign. It's a declaration for any patent application. It says you believe that you are the first and sole inventor of something.
Okay.
So truly you have to be the inventor. And so you can't take something from someone else, but say that person A invents something and invents widget. Person B independently invents widget, but invents it later. However, B got to the patent office first. B is going to get the patent. A is left out in the cold. So at the end of the day, it is a race to the patent office.
So there's a similar story in the business world of the original inventor of a color television tube. Not the original color television tube, which produced very poor quality color images, very dark screen and very pastel colors, nothing vibrant like we would see today. And he came up with a different technology that resulted in a much brighter and a little bit more color-corrected rendition. But there was a lot of work to do, but he was on the path. And RCA, which was the king of radio in those days, this was probably the 50s, late 40s, early 50s, before color TV was a thing, before TV was really a major thing. RCA saw the writing on the wall that radio was soon going to be obsolete. So they started selling televisions, black and white televisions, and they became known for televisions. And then they got wind of color TV, so they were experimenting with color TV, and then they heard of this inventor, they've seen the results of it, and decided to race him to the patent office. The problem was they had not yet reverse engineered his technology. They didn't have a piece of his technology. They just tried to figure out how he did it. And it was a complete race. And my understanding of the story, and I don't understand the legal details of it, but he had some type of provisional patent. And somehow, through the power of money, people in high places, the CEO of RCA managed to convince the patent office that it was not worthy of a patent. There was some things that the patent examiner didn't know, and they got something on appeal reversed. And it was almost like a Nikola Tesla story. He died without the fame, and RCA got the technology, patented it, and then licensed it, of course, to other manufacturers, and won the day, even though it wasn't their original invention. But that probably is a little bit more of an exception to a rule. But it was a great lesson to me of keep it quiet. Don't talk about what you're working on until you absolutely have something secure. And because he was looking for investors, he was talking about it. He was giving demonstrations on it and of it. And, that just led to kind of a public disclosure. And, to this day, they look at companies like Apple and there's an entire industry in publishing leaks that, leak out of Foxconn or leak out of Apple and trying to be the first to say what the latest iPhone is going to look like and the next generation iPhone is going to look like. But I would imagine all the legal stuff is done really under the cloak of secrecy, to the extent possible.
I try to tell my clients, even if we filed for the patent application, try to maintain everything under NDAs as long as possible, because the longer you keep it secret and the harder you hit the market, the better off you are. Because if you've learned anything from Kickstarter and these kind of programs, there are companies in Asia who are just waiting to see something hit on Kickstarter. You're raising money to build the product. They're going to hit the market before you are.
Oh yeah, by the time they see it, they're already in production. Yeah, absolutely. For first-time inventors or entrepreneurs, what's the first thing or the first step they should take before filing a patent application?
Well, I just kind of want to go back to something you said, which is extremely important. First thing I tell anyone who listens to me, I'll scream it from the mountaintops: do not disclose. I get it. Your invention is your baby and you want to show people your baby. You want to put it on Facebook. Look how cool this is. Look how great it is. No, if you really want to tell someone about your baby, call a patent attorney, because it has to stay confidential. They will listen to you. You can blab all you want, brag all you want. We will listen, but don't tell anybody else. So one of the things, inventors should possibly do is do their own prior art search if they have ever come up with an idea. Because if they find something, then maybe they shouldn't spend time and effort on moving forward. Now, that's not to say that they can't improve it over what they found. But, a lot of times inventors come up to me and we're like, hey, we found some prior art. They're like, well, what if I change this, this, and this? And I'm like, do not change your product for the patent if it's not going to be as marketable. At the end of the day, this is all about making money and protecting your money, not getting your name on a piece of paper that might not be worth anything.
Yeah, you're not buying bragging rights. Bragging rights come along with it, but that's not the motivation, right?
Yeah, a bragging right comes with a boat.
Yes, I agree with you. A big boat.
A big boat, yeah, not a skiff, That's...
So you've seen both sides as an examiner and as an attorney. What common mistakes do applicants make that hurt their chances of success?
Well, like we said, disclosure. A lot of times, when they're working on things, they're too close to it. This is why it's always, they say even an attorney who goes to represent themselves has a fool for a client. It's good to have someone who can take a step back and say, yeah, this is a good idea, but we don't have to be this specific about everything, because, a lot of times inventors will be like, it has to be made out of this metal. It has to be the best. It has to be everything. And I'm like, let's take a step back and understand that people will pay less money for inferior products all the time. That's what the whole knockoff industry is. So, when you're looking at it, try to take a step back and see how, if you had to design around your idea and your patent, how would you do it? And let's include that in the application as well, because then that will we'll include that in the application as well, and then it can serve as protection. Basically, don't only use patent to protect your product, but also use it to box out against people coming into your space.
At what point in an inventor's process or a company founder process, at what point should they involve a patent attorney? In the early idea stage, in the prototype stage, the proof of concept stage, when should they ideally reach out to Austin?
Well, that's if this is kind of your wheelhouse and this is something you do on the regular, you should just have a patent attorney that you can call and reach out to. When my clients reach out and say, have a new idea and we talk about it, it's not like I charge them for it or anything like that. Some may, but that's not something I do. I'm happy for them. I'm like, let's start. If we really get started down that road, I kind of suggest, at the beginning stages, really at the beginning stages, like people ask me, when do I know I have something that might be patentable? So I always say, did you solve a problem?
Hmm.
And if you solved a problem, there was something that might be patentable because some other people may have either, you know, faced this problem, couldn't figure it out, or people didn't even know this problem existed. Either case, that's probably when you might have something that's patentable. At that point, talk to a patent attorney, and sometimes I suggest let's get a prior art search done right then and there because let's not spin your wheels. There's a lot of information that can be found. I mean, it's research at the end of the day, and your idea might not be patentable at that point, but you might learn a lot of stuff that others have tried and done, and it may, and I call it shaking the tree. As soon as you see someone's idea, as soon as you give a smart person your idea, they're going to come up with something a little extra to it. And
Yeah, it
when you
sounds like
see
it's
the
more than patent research. It's really market research. It has, a lot of nuggets fall from that tree when you shake it. Not
exactly,
just legal, patentable stuff, but you know, if you find out that it's been patented for the last 17 years and there's not a single product on the market that's utilizing that patent, might tell you something that even if it got around the patent, maybe the concept just isn't sellable, or someone's
right.
just sitting on it. But that's unlikely if there's money to be made. So
Well, I mean, that's kind of the issue. I mean, I go back to, and I'm a kid of that. Well, I'm not a kid, but at the time it was South Park, and there was this
yeah,
episode called the Underwear Gnome Theory, and basically what it was, they would steal underpants, and then there's like, well, why are you doing this? It's like it's part of the business plan. And the business plan, step one, steal underpants. Step two, question mark, equals profit. And and the whole point is, so few people have both the idea and the question mark to make profit. So I wouldn't necessarily just look at it that way. That if there's a patent out there and no one's made money off of it, that it's not marketable because I tell my clients all the time, if you don't have a business plan to get this thing to market, we're just wasting your money here.
yeah. Now that's a really good point. What are
Yeah.
some of the misconceptions that entrepreneurs have about patents? Things that you just wash, rinse, repeat. You just constantly have to, get on your soapbox or get on your podcast and dispel those myths.
Okay. I get the call I get is this person's copying me. And you look at it and the inventors have to know, or the patent owners, it's the claims at the end that define your invention. And when you think of a patent, don't think of it like a wall. Think of it like a minefield.
Hmm.
And anyone can get through a minefield. It's just how hard and expensive.
Sure.
And when you write these patent claims, we're looking into a crystal ball. Think of it trying to defend your position where you don't know where people are coming from. So we write these patent claims to the best of our ability in a crystal ball because we don't know where they're coming from. So we do the best we can to have the broadest protection. But one of the things that people hire me for sometimes is like, hey, we want to build something, but we're worried about these patents over here. So we look at that minefield and we try to navigate around it. So once that claims are set, people know where the mines are, and then smart people are going to try to get around.
So I guess it depends on who your client is. If you have a client pursuing a patent, your goal is to drop as many mines in that minefield as possible. If your goal is to defend a client who's accused of infringing on a patent, your job is
Right.
to find the path of least resistance or least danger, I should say,
Yeah.
and avoid the minefields. How do you advise clients on balancing the cost of IP protection versus their budget?
Yeah. That one's tough.
Yeah,
I mean, it
particularly when
costs
you're
what
on the
it costs.
receiving end of that. Yeah, but I'm
Yeah,
sure you deal with that all the time, right?
I do. And, and I deal with small companies and they want to build and all this stuff. And I always say that lawyers can lawyer these people right out of business because we'll come in and, true, we should dot every I, cross every T, and do everything that we're supposed to do. But, when you're in startup mode, cash is king. And so you kind of need to find a good, partner attorney who's going to be able to be like, we might be able to push this a little bit down the road because you don't want to kill it before it's out of the crib by taking all the money and legal fees. Because, I mean, we talked about it. Like
starting a business. There's just so much regulation and stuff that you got to do. And especially if you're putting products on the market, there's just things that are going to eat up your budget super fast, the insurance, all this other kind of stuff. So, that's what I tell them is that, we're going to do the best we can. But, when you're dealing with, patents and your IP, it's going to cost you, $10,000, $15,000 to get a patent. And that's just what it is.
So what advice would you give to entrepreneurs who are afraid of sharing their ideas before filing? And how can they protect themselves while still moving forward? You mentioned earlier NDAs, right? And you also said keep it quiet. But obviously there's a fine line because they got to talk to somebody about it. So
Right.
what advice would you give to someone who's maybe overprotective and someone who is lacking in protection?
Right. So the big thing that I tell people is, yes, use your NDA. If you really have to talk to someone about it, like, consultant stuff, get an NDA. But the one thing that people don't seem to do is read the NDA. At the end of the day, it's a contract. And you have two issues here. A lot of times they don't read the contract or the NDA that states you got to mark this stuff confidential. There are
Yeah.
things you need to do as the disclosure, because they're just like, I have an NDA, everything's great. And I'm like, well, did you do the stuff that you were supposed to do? Did you mark this confidential? Were you clear that this was confidential information, this kind of stuff? And they're like, no, I have an NDA. I'm like, but that's not how it works. The other thing is that it's a contract. And in order for a contract to be binding, you have to have the quid pro quo, something for something.
Consideration, right?
Yes, exactly. The consideration. The problem is that they'll go to their friend and they'll say, hey, look at this, but sign this NDA. But they didn't give their friend anything.
What's in it for them? Right.
Exactly. So it's just a binding promise. It's not a true NDA. So at that point, I'm always saying, like, if you tell anyone and it's, you know, whatever, pay them $10. Put that in the NDA that you're paying them for their information or what their thoughts are, something, some kind of consulting, those kind of things. And you need to have the quid pro quo. You can't just tell grandma and say, hey, I told her and she signed the NDA. It's like, did you give her some lasagna? Or like, what's
right. Cookies. When I left my company to start, when I left my employer to start my company, I had an idea that I wanted to pursue. I pitched it to them. They said, no, we're not interested. So I quit and pursued that idea on my own. And they once I produced the first press release showing the product, they sued me. And this was in California, so they sued me for violating my non-compete contract, which is a former California attorney. Non-competes rarely work in California, but there was no non-compete. So then they accused me of stealing the contracts, on my way out. They also accused me of stealing their proprietary confidential information. Okay. So on our side, we subpoenaed, everything we could through discovery, and we got copies of all their like schematics and diagrams and code and things like that were attorney's eyes only. I wasn't allowed to see it, which I understand. Not one document was stamped confidential. Not one. On all the in the legend sections of all of the blueprints, nothing about confidentiality. When we deposed them, we asked if where do you keep this stuff? Oh, in a filing cabinet. Is there a lock on it? No. And you already understand where I'm going with that. That's when I learned that for something to be deemed confidential, it needs to be treated as confidential. You can't just retroactively deem something confidential. If they treated it, if they just left it out, if they hung it on a wall, and maybe even included in some advertising, all of which happened, it's public domain at that point, because they didn't own a patent on anything, or a copyright or a trademark or anything. So even though I didn't copy anything, in fact, in the middle of the trial, it was a bench trial, so there was no jury, thankfully. And we had a pretty crotchety judge, and we were his last case before retirement. We were the only thing separating, him from a beach or a golf course. And he was no nonsense, very fair, but no nonsense. He would sanction each side if they, played games. And at one point, they introduced into evidence that supported their claim. They thought supported their claim that that I used my unique position in the company to learn their unique business practices that I would not know without being a trusted employee. They were so proprietary. And one of the things that they accused me of was stealing their vendor list. And the one bit of evidence they brought was a Grainger catalog, that I buy things from Grainger and they buy things from Grainger. And the only way I could have known that is to work there. And fortunately, the judge must do he must have a side hustle or something, because he said, he stopped him, because as a bench trial, he can just stop and ask questions. And he said, I've got a whole bookcase full of old Grainger catalogs. You mean to tell me that I stole your stuff too? And of course, that was ludicrous. And he was pretty much laughed at that point by the judge. The judge just kind of move on, just drop that, move on. I don't want to hear any more on that. Looking ahead, how do you see artificial intelligence or global collaboration affecting the future of patents and innovation in general?
Well, I mean, that's a big one. I mean, right now, so remember how I said, like, when you file for a patent application, you have to say, I am the true and sole inventor. So right now, AI can help you invent, but it can't be the inventor. Only a natural born person can be an inventor. I'm already getting people call me up saying, hey, AI wrote my patent application. Can you file it? And I'm like, no, I'm not going to do that. I've read too many of those and realized that it's not up to par.
Yeah.
Now, that's not to say it might not at some point. But AI has some pretty interesting problems in the fact that, say you have pictures of plumbing, right? Perfect plumb job. But say you have 2 and there are 3 in there that are totally messed up, but no one told it was wrong. You now have a poison pill in that learning.
Yes. It only knows what it's been told. It doesn't. Right. I think AI is so good, humans interact with it as if it's a human. And it is, I think the fallacy of AI is that we call it AI, artificial intelligence. I really think it should be called acquired intelligence. If I went to a terrible university and was educated incorrectly, I'm going to be very educated and not very smart, in the big world. So you're right. I make a point. I use AI all the time to do research on my guests and things like that. It's just a faster way than Googling 20 websites. And I have to tell it, if I ask it to suggest titles for an episode or whatever, based on, information it found on my guest, I have to actually include in the prompt and base the suggestions on factual information. And sometimes I'll see a title, like, for example, I'll make something up. I'm going to interview you. I say, do some research on Austin and give me some, based on, the questions I'm going to ask. I upload the questions I'm going to ask and say, write some titles for it. It might say, Austin Bonderer, a patent attorney and a world champion wrestler. And then I'll say, where did the world champion wrestler come from? And it might say, well, statistically, most patent attorneys are into wrestling, so I just put that in there, but I can't find any validation for that. So I have to tell it to basically don't hallucinate, tell the truth, and show me citations. So I've got and the nice thing about like ChatGPT anyway, I'm sure the rest do it too. I don't have to keep telling it that. If I tell it that once, it remembers that. And it always shows me citations that I can reference. But yeah, I think AI is an amazing technology. We're in the middle of watching a revolution happen, just as impactful as the steam engine, just as impactful as electricity, just as impactful as the internet. It's going to change lives, but it's going to be a bumpy transition, and we're going to over rely on it for a long time. That's just the way innovation works. Just a couple more
And I
questions.
will say something too,
Yeah,
that, like,
sure.
advice to inventors, anyone who's looking at this. I'll tell you my thoughts, because so many times when you're doing your own prior art search, AI just seems so great to be there because you're
Hmm.
like, this is my idea, here it goes. The courts haven't decided yet, but in my opinion, you are literally disclosing it to the largest knowledge database out there.
Hmm.
And you're like, well, no one really knows it. I'm like, but the database knows it.
Yeah,
And if someone happens to put something in there, it comes out. So I don't know if that's considered public disclosure yet. I'm not going to let my clients be the ones to figure it out.
right.
So I always tell them, don't use AI to do your prior art search.
I'll tell you, Austin's going to end up in front of the Supreme Court. It might be one of your clients that are the test case for it.
No, no, no. I always tell people, if you see me in court, bring bail money because I'm in trouble.
Right, right. I think that's, we talk about myth busting. I think that's one of the myths that layman people have, is that every attorney, stands in a courtroom. I think a very small, like single digit percentage of attorneys actually practice in a courtroom. Is that a
Yeah.
pretty correct assessment?
That's my understanding. I mean, yeah,
Yeah.
I've never been inside. I mean, I've worked on some litigation as an aside or advisor and stuff like that, but never. I'm not going to court.
Yeah.
Too much work. It's ridiculous.
Yeah. I remember that from my experience. I've only been involved in a court case, once, thankfully. But it was deliberately and painfully slow, and one of the most inefficient processes one can imagine. But the consequences are so high and they are binding that I appreciate that. But we had a case. We were in Superior Court, and it was a fast track case. There was an experimental program that the Orange County Superior Court was doing at the time, that if you were gone on the fast track, you were guaranteed, and this is just for civil cases, you were guaranteed, filing to judgment in less than 365 days, so a year.
Wow.
And our trial took 5 days. So, 360 of those 365 days were non-trial, and only 5 were trial. Then it took a month to get the verdict. So even though we were fast track, it still took a year. And that's a year of my life I'll never get back. It's a year of cash drain, because the cash goes out on a fast track basis too. And
yeah.
It was a year of depositions. It was a year of distraction. It was just a horrible, horrible year, a year of worry. So yeah, I'm grateful that I haven't seen the inside of a courtroom except for jury duty since then. We're about out of time, so I just have a couple of quick questions. What one piece of advice would you give to entrepreneurs who want to protect their ideas but feel intimidated by the process?
Talk to patent attorneys. Are not. I always tell people I am an engineer with a law degree.
Right.
So don't lump me in with those attorneys and lawyers. They ruin everything. So feel free to call me. I'm more of a like tech type nerd type stuff. I'm more into that than I am the law stuff. I mean, yes, I do practice the law, but that's the stuff that I do. So
That I think is very impactful. Final question: how did you define success when you first started your company, and how do you define it today?
oh, could I feed my family would be the first
Yeah.
one. Like,
Yeah.
was I making the bills every month?
Captain
That was
Obvious
kind
there.
of-
Yeah, duh. Right.
Yeah, it's like, are we going to have enough money this month? Is anyone going to be upset with me because I went out on my own and didn't work for this company anymore? So that was kind of the thing. Now it's I truly value my off time. I'm not going to lie. I try to manage my business to where I have a huge, reasonable work-life balance. And I've accepted the fact I'm not going to have that big boat, right? I might get that skiff, I might be able to go fishing, but I'm not going to have that big old boat. But I'm happy with that. I'm happy with the ability to travel, see new places, and do all this stuff. So that's kind of how I measure it. I truly believe that I work to live. I don't live to work. Or wait, it goes opposite. What? I think you know what I'm
You
trying
work to
say.
live. No, you work to live. You don't live to work.
Yes.
Yeah, you had it exactly right.
Yeah.
And I think that's a huge takeaway. To me, that's the definition of success. define success as freedom, which is a little bit of a cop-out answer because freedom can be, monetary. Because certainly if you're making a good income, you're free to do more things you want to do. But I even think of it as a higher octave than that. It's the freedom to spend time with family. It's the freedom to maybe engage in some philanthropic activity. It's the freedom of so many different things. And like you, I would have defined success by the brand of car in my driveway, the number of feet and the horsepower of my boat, and all those things, and the brand of watch I'm wearing or whatever. Those are the last things for my mind now. And I'm not minimizing money. Obviously, we can't do good things for the world. We can't donate to charities. We can't speak to students about entrepreneurship or, in your case, patent stuff, if we're not at least eating and serving our family. So one comes with the other, but I think the money is the means to a greater end. And I think that people who have been in business long enough realize that. This is episode number 39, and the 38 entrepreneurs before you all had similar, meaning a similar story, meaning their version of success when they started their company had changed to now, right? And every single person, including you, that I've talked to, has had a much higher octave, greater perspective definition of success. And I think pretty much all of them, if not all, most of them had, I wanted to eat, man. I needed to pay off my car or whatever the case may be. So Austin Bonderer, I really appreciate the time that you've spent with me. I'm going to release you to go back to billable hours now. And you can use this as like well, there's no one judging you, but if you're ever in front of the bar, here's some pro bono work that you've done here. So you're educating society on patent law best practices. But thank you for spending all the time with me. Thanks for sharing your journey with me. And more importantly, educating me and my audience on the ins and outs and best practices associated with patent law. I really appreciate the advice.
Mike, I appreciate so much you having me on the show, and I've enjoyed every moment of it. So
great. Well, so have I. For my audience who's watching this on YouTube, just look down here somewhere and you'll see a link to Austin's patent office website. And if you're listening to this on your favorite podcast app, when it's safe to do so, don't do it while you're driving, because then you might need another type of lawyer. Go ahead and look at the show notes on your favorite podcast app, and information on how to get a hold of Austin through his company website will be there as well. So Austin, thank you very much. I wish you continued success. And, if you have to get a bigger boat, get a bigger boat. You've earned it.
I wouldn't mind it.
Yeah, there you go. All right. Thanks, Austin. I appreciate it.
Thanks a lot, Mike. Have a great day.
You too. And that's a wrap. Thanks for joining me on this episode of the Reluctant Entrepreneur Podcast. A special thanks to Austin Bonderer for being my guest on the show. We've been very busy recording future episodes with fascinating guests, so be sure to subscribe and get notified when new episodes drop. And one personal favor, if you're watching this on YouTube, give us a like and subscribe. Those two simple clicks really help us expand our reach. If you're an entrepreneur or know someone who would make a great guest, I'd love to hear from you. Visit reluctantentrepreneur.podcast.com to apply or recommend a guest. You can also reach me directly at mike@reluctantentrepreneur.podcast.com. And a quick shameless plug, if you're interested in my book, The Reluctant Entrepreneur, Anatomy of a Business Startup from Uncertainty to Unstoppable, it's available in paperback and Kindle on Amazon, and as an audiobook on Audible and Amazon. That's it for the shameless plugs. Thanks again for listening or watching. Until next time, be unstoppable. I'll see you again soon.